Hello guys, welcome to this video. Today we are going to look at the case of Kaushal, Kishor and etc versus Union of India and others. So without further ado, let's dive in. We begin by looking at the preview and the significance of the case. This case discusses the scope of Article 19(1) and restrictions impossible by Article 19(2). This case also handles the responsibility of the government for its ministers, and also another part that this case handles is the concept of constitutional tort. So it is important to note that three key distinctions and issues are handled in this case. Just to repeat for better and easy understanding for you, one, we say that this case addresses and discusses the scope of Article 19(1) and restrictions impossible by section Article 19 section 2. Two, if said that the case discusses the responsibility of the government for its ministers, and then thirdly we find that it discusses the concept of constitutional court. Let's understand a few terms before we get into the case. The first term that we want us to understand is a writ of petition. A writ of petition is a formal request to a higher court to issue a writ, which is a legal document that orders a person to do something. So a writ petition was filed against a statement. So let us now examine the case details. In this case, a writ petition was filed against a statement made by the then cabinet minister of Uttar Pradesh in north central India, Mr. Azam Khan, on a gang rape case. He was ordered to issue an apology in 2017 by the scheduled guests. Scheduled guests for simply means designated groups of people among the most disadvantaged groups in India. So these groups of people sought an apology. They were hurt by the remarks of the cabinet minister of Uttar Pradesh in north central India, Mr. Azam Khan, on a gang rape case. So he was ordered to issue an apology in 2017 by the scheduled guests. So the matters was referred to a constitutional bench, and this is what the constitutional bench had to say on this. So before we look at the opinion of the constitutional bench, it is important to look at important articles and what that are significant and important in this case. One is the Article 19 of the Constitution of India, guarantees 6 fundamental freedoms to citizens. Article 19(1) of the Constitution of India lists the rights. Then Article 19(2) lists the exceptions and restraints on those rights. Also Article 21 of the Constitution of India is all about the right to life and personal liberty. We also have Article 75 and Article 75 Part 3 and Article 164 Part 2 that talks about the collective responsibility of ministers. So as we spoke, we said that, just as a little recap, that this minister spoke dangerous or remarks on a gang rape case, and scheduled guests ordered for an apology on this matter. So this matter was taken to a constitutional bench to really deliberate and find out what is legally wrong and right on this matter. In other words, they were interpreting the law on this matter. So the constitutional bench made the following findings. One is that additional restrictions not found in Article 19(2) cannot be imposed on the exercise of speech under Article 9(1) of the ministers and members of Legislative Assembly of India. So this finding by the Constitutional Bench simply means that you cannot add law that is not there just to prosecute a case. We have to follow and obey the letter and spirit of the law. Secondly, the Constitutional Bench found that grounds mentioned in Article 19(2) for free speech are exhaustive. Another finding of this bench is that under the guise of invoking other fundamental rights, additional restrictions over and above those prescribed in Article 19(2) cannot be imposed upon the exercise of one's fundamental rights. So it is impossible to add more to what the law has. It will be wrong for the Constitutional Bench to do that. So Article 19(2) is where it lists exceptions and restraints upon the rights that were listed in Article 19(1) of the Constitution of India. Article 19 being the article that guarantees 6 fundamental freedoms to citizens. So it's important to keep this at the back of your mind, because they are very, very important articles of the Constitution that will play a huge role in this case, that are very, very important. So we have number 5 finding of this Constitutional Bench. A fundamental right under Article 19 or 21 cannot be enforced even against persons other than the state. A fundamental right under Article 19 or 21 can be enforced even against persons other than the state and its instrumentalities. This was a finding of the Constitutional Bench. In this finding, 4 judges were of this opinion and 1 dissented. Justice Nagaratna dissented with the majority on this issue. So that was another. Now we look at another issue that the Constitutional Bench deliberated upon. The issue was whether state is under a duty to affirmatively protect the rights of a citizen under Section 21, even against a threat to the liberty of a citizen by acts or omissions of another citizen or private agency. So the Constitutional Bench was of unanimous opinion. It held that state is under duty to affirmatively protect the rights of persons under Article 21 whenever there is threat to personal liberty, even by non-state actors. We continue. Another issue that the Constitutional Bench deliberated upon was, can a statement made by a minister be attributed vicariously? Vicariously means done for the government. So can a statement made by a minister be considered done for the government, to the government itself, especially in view of the principle of collective responsibility? If a minister issues bad or negative aspects, can it be attributed to the government? Is this consistent with the principle of collective responsibility? So the Constitutional Bench thought about this, and it was held that generally collective responsibility of the Council of Ministers correlate. Correlate means in which one thing affects or depends on the other. So generally, collective responsibility of ministers is affected by the decisions of the Council of Ministers and not to every statement made by every individual minister. So this simply means that the collective responsibility of the Council of Ministers is affected by the decisions of the Council of Ministers and not to every statement made by every individual minister. So collective responsibility to summarize this statement, it simply means that collective responsibility is applicable only when a council of ministers makes a decision, but when one minister makes a decision, then collective responsibility cannot arise. It's very important to really distinguish clearly that collective responsibility lies when a council of ministers makes a decision, and not every statement made by every individual minister. So in other words, a statement by one individual minister nullifies collective responsibility. Secondly, it was held that each individual minister is responsible for the decisions taken collectively by the council of ministers. The flow of stream in collective responsibility is from the council of ministers to the individual ministers. The flow is not reverse, namely from individual ministers to the council of ministers. Therefore, a statement made by a minister, even if traceable to any affairs of the state or for protecting the government, cannot be attributed vicariously to the government by invoking the principle of collecting responsibility. We go forward and look at another issue that was deliberated upon, and this issue is whether a statement by a minister inconsistent with fundamental rights constitutes a violation of such constitutional rights and is actionable as a constitutional tort. So it was held that a mere statement made by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution may not constitute a violation of the constitutional rights and become actionable as a constitutional court. But if, as a consequence of such a statement, any act or omission or commission done by the officers resulting in harm or loss to a person or citizen, then the same may constitute actionable constitutional tort. So the final decision was additional restrictions not found in 19.2 cannot be imposed on right of free speech. Secondly, Article 19 and 21 can be enforced against private, individual and entity. Third is that minister's statement in official capacity cannot be vicariously attributed to government under collective responsibility. And the fourth decision is that minister's speech will amount to constitutional tort if it leads to acts of officers harming people. Of all this, we had one judge, Justice Nagaranda, who was of dissenting opinion. So Justice Nagaranda was of the opinion that Article 19 and 21 cannot be made available against non-state actors. The duty cast upon a state a negative duty. Secondly, the Justice Nagaranda was of the opinion that a statement made by a minister is traceable to any affairs of the state for protecting the government can be attributed vicariously to the government by invoking the principle of collective responsibility. So as long as such a statement represents the view of the government also. So this is a very important case when it comes to the whole issue of collective responsibility. This is a very, very important case in India because it really teaches us about the principles or the rules that are followed in India when it comes to collective responsibility, especially the collective responsibility of MPs and members of the Legislative Assembly and other high-tier government officials. So this is a very, very important case to really remember. So in this case, it is important to note the key constitutional provisions of India. One is Article 19 that guarantees 6 fundamental freedoms to citizens, Article 19 Part 1 that lists the rights, and Article 19.2 that lists the restriction and restraints. Also, we have Article 21 that talks about right to life and personal liberty, and also Article 75 Part 3 and Article 164 Part 2 that talks about collective responsibility of ministers. So this is a very important case law in a law, especially the law of India. Thank you for watching this video. Like, share and subscribe. If you have any questions on the case, you can freely put in the comment section and I will handle them immediately. Thank you for watching this video. Like, share and